Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about the Totality Principle in sentencing. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Simeunovich was charged with a number of counts of driving while disqualified. He was currently serving, at the time that he was sentenced for these counts, the remainder of a sentence for criminal negligence, which had 3 years and 10 months left on his sentence. In exchange for his guilty plea to the 5 counts of driving while disqualified that he had racked up during the time that he was awaiting being sent into custody, the Crown sought a sentence of 8.5 years of jail. And the Crown asked for that sentence to be imposed consecutively to the punishment that he was already serving, meaning that he would essentially do another 12 years in jail from the point that he was sentenced. The range of sentence that the Crown sought was outside the guidelines of what normally would be imposed for those types of offenses. And the court justified its deviation from the range on the basis of good public policy. And this case obviously raises important issues for the Supreme Court of Canada to consider, because although sentencing ranges are just guidelines that judges don't necessarily have to follow, and as long as a judge doesn't deviate from the minimum or the maximum sentence imposed at law, absent a constitutional challenge, any sentence that's available at law is technically within the range of available sentences, even though the case law may make the range a lot more narrow, and judges are entitled to deviate from sentencing ranges. But when a judge deviates from a sentencing range, there are concerns that doing so in reasons that are not very fulsome is unfair to the accused. Accused persons rely on sentencing ranges to make decisions about whether or not to take charges to trial, whether or not to plead guilty. And further, when people plead guilty to multiple charges at once, there is an obligation on judges not to impose a sentence that is so high that it offends against the principle of totality. The whole sentence still has to be reasonable, and an 8.5-year sentence for driving while disqualified is well outside the range. The Supreme Court of Canada had an opportunity here to really clarify the bounds within which judges are entitled to deviate from sentencing ranges, especially when somebody is already serving a lengthy period of custody and is going to be serving a longer period in custody. At the end of the day, simply good public policy or this nebulous concern about protection of the public isn't enough, in my view, to justify departure from the range. And it would be nice to hear from the Supreme Court of Canada a better, clearly articulated test of when judges can depart from the range so that people coming to their sentencing hearings, especially facing multiple charges who are already in custody, have more certainty about what's going to happen. Because otherwise, individuals may choose to take their charges to trial, banking on the likelihood that they could be acquitted, banking on the likelihood that something may happen that causes the charges to be dismissed, such as unreasonable delay. And if you're already serving several years and your sentence is going to be consecutive to what you're serving, there's really no downside risk to scheduling it to trial, if you were to know that it's likely that a judge might depart from the range. This is why a clearly articulated test for when a judge can and should do this is so important for certainty in the criminal justice system. And it's unfortunate that the Supreme Court of Canada didn't take this opportunity to address what on its face really sounds like an excessive amount of jail time for the nature of the offenses that were committed. Unfortunately, it'll take another situation of very lengthy jail sentences imposed for the court to take a look at how ranges inform the totality principle and to provide clearer guidelines to sentencing judges. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.